Welcome to this Euranet Plus debate on child-friendly justice presented within the Citizens Corner concept. The debate is produced and hosted by Euranet Plus and Castilla Léon Radio Spain, a member of the Euranet Plus network. The debate can be followed live in the European Parliament on our Euranet Plus Inside website, on our Facebook profile as well as on Twitter using the hashtag Citizens Corner. I'm Brian Maguire. Joining us today to discuss child-friendly justice in Europe, Pavel Čáky, a Christian Democrat MEP from Slovakia, Shadow Rapporteur for the Directive on Criminal Proceedings, Procedural Safeguards for Children Suspected or Accused, Francisco Fonseca Murillo, Director for Criminal Justice at DG Justice and Consumers, Dr. Astrid Posiatlovsky, Head of Sector for the Rights of the Child at European Union Agency for Fundamental Rights. He's also the main author of the report Child-Friendly Justice, Perspectives and Experiences of Professionals, Mariama Diallo, Children's Rights Specialist and Eurochild Representative. We're also joined by students from a university campus network. Irene Benedito from Barcelona, Beatrice Bungo from Romania, and Anna-Maja Kopias from Finland. Welcome to all of you. Pal, let's start with you. This report on criminal proceedings and children suspected or accused, what are the main points of that?
Maybe you know I am from a post-communist country. I was 2 times the Prime Minister of Slovakia. So I see the situation also from the position of the member country and also from the position of the European Union. And I'm happy to declare now that it seems the European institutions see their responsibility. The preparation process of the directive on procedural safeguards for children suspected or accused in criminal proceedings is now in a relatively good position. The European Parliament already made his work. I was a shadow rapporteur from the side of the European People's Party. And I think the main elements of these documents are firstly, to try to prepare a friendly-oriented document to the children, and secondly, to try to help the reintegration of such children to the society. If you ask me, I would like to name maybe 5 basic elements of the document.
Quickly.
Yes, of course. There are only the main structure. The basis of the main structure of this document is to meet right to information, right to have the holder of parental responsibility informed and be present, right to a lawyer, right to protection of privacy, and maybe that's also important, right to specific treatment in case of detention. So there are maybe the 5 basic elements of this document.
Mariama, the right to a lawyer on this, it struck me reading one of the reports that it's extraordinary that children are expected to pay for their own legal counsel. How does that happen in modern Europe?
Yes, well, in fact, in Europe, not every country have really developed a very accessible legal aid system. So this is indeed something that would need to be developed, to see that actually every child that is suspected of an offense has the right to have access to this service. It's a right of the child recognized by the UNCRC. So we believe that this should be able to be done without any derogation limitation. So this definitely will needs to for the state members to be implemented in national legislation.
Okay, Astrid, this is dealing with criminal proceedings, and your report deals primarily with civil proceedings, largely. The issue when it comes to the provision of criminal with legal access, how do we find this across Europe? Is it balanced?
Let me start shortly about our report, because there we look into the situation of children in different roles, victims, witnesses, and party proceedings in criminal and civil law. We do not specifically look into children who are suspected of a crime. We can identify that what we see in our findings based on the interviews we did with judges, lawyers, psychologists, social workers, police officers, that there's a great variation of practices, how children are treated and how they can participate in proceedings, whether they're appropriately protected and informed, for example. But there's also great variation within member states. And based on our findings, we can say that concrete measures of protecting children, for example, avoiding contact with the defendant, appropriately informing a child on checking whether the child understood what's going on, is not standard practice throughout the countries, the EU. But of course, we have different promising practice in different countries.
Okay, how do you evaluate what a child is capable of understanding in a process?
I would say, or not, that's what also the professionals say, but we also learn from the interviews with children that children are often underestimated in what they understand. They're very clear on the importance of being heard, and they do appreciate the opportunity to be heard and to talk and to be listened to. The problem often is that children are not always seen as people who have to be protected specifically. You have specific vulnerabilities. So the way people talk to them, professionals talk to them, the judges, needs to be adapted to their age and their level of maturity, and it has to be an individual-based approach.
Okay, Francisco, we have a European justice system which should be harmonized. Would you agree?
Of course, that is why we are working, no?
So why is it so difficult to deal with so many member states and to implement these safeguards for children?
Well, the reality is that all national systems has had very good systems of protections, very good system of rule of law, deep national traditions on these issues. So the basis is very good. But I agree with you, Astrid. We need to learn about the practices, and your report is very good. Just in order to show the others, I am not imposing you, but you can take advantage of all these practices. That is the first part, really. Benchmarking. That is the first part. The second part, of course, is to ensure a minimum set of rules harmonized at the European level. The European Deputy, Mr. Schatz, sorry for the pronunciation, Shaki, was perfectly agreed. We are in the very good way to finish the work on the directive on procedural guarantees of children under the next presidency, under Luxembourg. We have in intensive discussions, Council, Parliament and the Commission. We have, correct me, on the 20 or 21st May, a second trilogue in Strasbourg, and we really expect that we can have quickly a conclusion of the work.
Okay.
Of course, there is remaining issues like the legal aid.
Well, when it comes to educating judges and those involved in the legal process, what did you find as you went through this discussion and preparation of the report? Do you see that there is an education system, an education component really missing in this process?
I think this question has maybe two levels. The first level is what was mentioned by others also, is the political wish and the level of the legal document. I think we are really on a good way. That's now a trialogue between Commission, Council and European Parliament. There are very good discussions, and I'm sure that we have a chance to make the document as soon as possible. But there is also here another level, and the application of this document. The application of this document, especially in the member countries, and as I mentioned in my first introducing speech, I am from a post-communist country, so I see that there are a lot of differences in the application of these legal documents in some member countries. So that's the reason why I think the European institutions must be active concerning this question, and I am happy to declare it that it seems now it's whole of these processes are a good way.
Okay, Astrid, then we'll come to Irene for another question. Astrid.
I would like to pick up on the point you made, Mr. Chucky, is on the application. Because what we looked into is the experience of it on the ground, on the treatment of children and the practices professionals use. And we can see that there may be the laws in place, but the procedures to transpose them, implement them, are not necessarily in place. Or the legal frameworks are too general. So, for example, I appreciate in the Procedural Safeguards Directive, in the draft, that it specified what does it mean, the right to information, for example. It means that it has to be clear who informs the child, and it has to be clear on what, on the rights and the procedures, and also on the outcomes. And what we find from our interviews, this is not in place systematically. It is too much on the discretion of the individual judge, for example, individual professional. The child can be lucky or cannot be lucky. So we do need to have to harmonize this approach. And the same goes for training.
Irene, do you have a question for the panel?
Yes. Traditionally, children's justice is imitating adult justice and adapting it to the needs, to the specific needs of child. But under 18 justice is more focused on recovery programs, prevention, reconciliation, and social cooperation. And its results are better than adult justice. In Spain, for example, the 80% of cases, the child don't reoffend. And in the adult justice, the 20% don't reoffend. So the statistics give child justice more prestigious. It's time for adult justice to imitate child programs.
Mariama, first of all, do you think that the child justice system is preventing reoffending, first of all? And secondly, are there lessons for the adult system from the child system?
Well, a well-designed child justice would have an aim to make sure that sufficient educative services, sufficient social services are implemented, so that the child that has committed an offence, which, by the way, very often is also victim from the system or victim of a situation because he finds himself in a risk of poverty or social exclusion, or because there are trafficking networks behind the fact that he has been, for instance, child stealing. So this has to be looked into. So a system that would be working well is a system where, when the child has committed an offence, we would look at what are the measures to be taken, and we would need to look at alternatives, for instance, to putting a child, for instance, in pretrial detention if the offence committed is important. And this is something that Eurochild, as a network organization, has been working quite intensely in it, together with the International Juvenile Justice Observatory, and a report was released yesterday, in fact, on this, and it's about investing in child-friendly justice and looking at the situation of the economic situation of their resources available, and this needs to be focused on educative, go away from the punitive approach, go into the educative approach. And I think at the European level, unfortunately, is not the same. And for instance, in some Eastern Europe countries, the punitive approach is more developed.
Francisco, let me bring this into a very clear definition. When it comes to trafficking, child slavery, prostitution, where the child may be seen by the police as the perpetrator of a crime, and yet really the child should be perceived as a victim. How is our European criminal justice system rebalancing to protect the child in this situation?
I think so. We have on force 3 very important directives. One directive on victims' rights, including the most vulnerable persons, like the children. And we have 2 specific directives concerning the prevent the sexual child abuse and fighting against pedopornography and trafficking of human beings. So we have the legal instruments. Of course, these legal instruments, like the directive on procedural rights, they are not unifying the 20 legislation, but harmonizing. There is a muscle maneuver for national practice. What is our problem? We need to have a full picture of the real situation. That is why this report is very important. To see, one thing is the Article 11, 12, etc., and the other is reality in all different countries. Because with all this report, we can evaluate the application of the legal acquis, and we can introduce more unifying, please, with brackets, rules on these cases.
Let me ask you, how do countries which say we don't have the money to train our judges, or we don't have the money to protect the victims with special kinds of courtrooms, how does the European Union assist with this kind of implementation on the ground?
We are insisting very much in grants in order to help practitioners to implement the best practices. 2013, I remember well, we have spent almost 3 million euros just in order to implement on the grounds how to implement the practices. But of course, there is also a responsibility not for the European institutions, but for the European society, the European institutions as a whole, to be sure. I can say, Astrid can say, Austrians or whatever, or Polish are very good in this concrete point. Please apply that. But it's also on the ground, and we need to.
Okay, this is a question from Anna-Maya first, and then we'll come back to Astrid. Anna-Maya.
When the child has entered the judicial system, how do we bear the costs of the safeguards, for example, the medical examinations and individual assessments, so the children don't have to do that?
Astrid, how do we apply the cost of legal representation of child protection in an appropriate way?
I think it's also a bit to the question for the Commission.
From the Parliament.
The Parliament.
We'll come to the Parliament in just a second.
My answer will be a bit more indirect when we talk about the costs, which we need to consider. We need to consider the balance of the costs. And if we have appropriate safeguards in place, like specific facilities to video record hearings, trained professionals, then the hearings are produce statements that are more valid and less influenced, and the children are less scared and anxious. So this means there are less hearings necessary,
so
and proceedings get shorter. So we save a lot of time.
Okay.
And not to forget the re-traumatization we have to avoid of a child.
Paul, did the parliamentarians, did they understand this process, where the cost can actually be reduced with a better justice system, a better process?
I think yes, and I hope yes, but of course that's a normal question to the Parliament and the members of the European Parliament, but that's not an isolated question only for the Parliament. So I'm very happy that there are now a lot of possibilities to organize roundtables, to ask the position of experts. There are here some written forms of some documents, so that's very important that we have a good discussion, a really good discussion on this question. But on the other hand, I am also a specific member of the European Parliament because I am a deputy chair also of the Committee of Petitions. And I was, frankly saying, very surprised how many petitions we have concerning children's rights. So maybe something is not a well-functioning system, or some details of the system are not well-functioning in the European Union. That's the reason why I am happy to see now new energies to solve this question on the higher level. And we are preparing also some fact-finding missions to the member countries, and we are ready to invite the experts, the representatives of NGOs. So we have an ambition to create a really effective dialogue on this question.
Mariella, the role of NGOs, role of civil society in this, how important is it?
Yes, well, we believe that this is essential, and in fact, we can see that many of the initiatives that were as child-friendly were impulsed by NGOs in the European Union. If we take the example of the units in France that are medical legal units where children can be heard in a manner by doctors, they collaborating closely with the police. So in Croatia, where you have a children's house where there is an example of multidisciplinary work. So here NGOs have a certain expertise that needs to be, we believe, tapped on. They are very close working with the children, with the families. They know the realities of the local communities. They are closer to the ground. So this really needs to be, this is a source of, a gold source of information that needs to be sufficiently recognized, but also, let's say, invested in. And one of the shortcomings, indeed, when you have a legal framework, and indeed the way to transcribe it into national local practices, is that gap that there is to want to have certain procedures in place, but then not having the means at the local level. This means working with the local authorities also, together with the NGOs, so that the needs of the child can be understood and can be well evaluated. Okay. And this is important.
Francisco, is this a problem of too much subsidiarity being permitted, and that the cultural differences are being respected too much?
Of course, we need to respect that. That is obvious. But frankly speaking, I think that to consider that is a problem, I don't agree. I mean, to have a friendly justice for child. Why? To have a friendly justice for child is more expensive. Why? We know that in all our national systems there are specific measures to have video hearings for children, to avoid, in case of sexual abuse, that the parents are there, to have special rooms, etc., etc. But the best way we can do is to explain all the 20 member states, you are doing that. But how do you imagine that if you do that is even cheaper than that? That is the real question. That is the role of the European Union, to finance NGOs, to finance practitioners in order to have, and sorry for the words, a specialized army to assist children in procedures. For example, if you go, that is not, it's a moving target, but if you go to the e-justice portal of the European Union, you have a set of national measures that we recommend that could be applied on the 20 member states. At each practitioner, each NGO, each judge can see that it's even better to have a teddy bear in a room than to have a ball. I don't know. It's a question to discuss on the concrete question.
Okay, Astrid, is this the case? Is that should there be more leadership in this as well? Should there be a more clear direction where people really understand that the teddy bear in the room has something that has to be considered, that the judge doesn't have too much discretion when it comes to this?
Mm-hmm. No, yeah, I would totally agree with that, and I'm happy to support what Mr. Maurier was saying. It is about standardization. The point is really it's about awareness, and it's about professional behavior, and this is not costly. It means that the professionals are aware how to ask a child about something, that it helps a child to make breaks during a hearing. It helps a child to remove the wigs and the gowns, to adapt the language. And this can be particularly multidisciplinary cooperation. It's an awful word, but helps a lot because professionals learn from each other within the country, but also across regions. There are very clear practices also for contact points, also what Madame Díez was saying. NGOs have good initiatives, for example, producing child-friendly material. This can also be used for other situations in other regions, or having intermediaries to be in contact with the child and the judge, for example. They are really, really good practices which one can learn from each other within a country and across.
Yes, I want shortly just to intervene about the cost argument, because this is a very tricky one, and in time of economic crisis, and this is the work we have gathered in during the annual conference of Eurochild last year. More than 40 experts in European that work in the European countries from different sectors to think about building an economic case for child-friendly justice. And there were 3 points that were mentioned, which are quite interesting. Is to think of it less, and this is less expensive than that is more. What is the social return on investment? So thinking about the future also, to say investing now in alternatives to detention, for instance, investing in new ways such as foster care for children instead of putting them in detention, which are very costly to have detention systems, is actually makes that the child can be better integrated in society and can become a future citizen, active, employed. So investing in sufficient educative social services, this is important, and investing in data collection also sufficient. I believe that the NGOs have also a possibility to have enough contact with children and data. Which are the children we are talking about? What is their profile? And this needs to be harmonized also at the European level. And the third point was indeed to ensure that children are participating and are heard through this process, to see that if we hear what their needs are, it's actually better to develop the policies around them.
All right, let's take another question from Beatrice.
Do you think that it could be essential for children to learn about justice at school? This could be a good way to prepare them in case of participation of a judge or in a judging place.
Astrid.
Yes, I think that's a really important question you're asking, and a very relevant question. And from the interviews with the children, we do see that there are differences between countries, and we can clearly connect them to their human rights education at schools. We do have examples from countries like also the UK and Germany, where they are much more aware of the rights, independent from the specific situation they have been in, and that they give much more statements which show an empowerment of them They know their opinion is important. And we do have in other countries children who just accept pretty much everything because they think they don't have any chance and they don't have any rights.
Okay, Francisco, there's a constitutional element to this as well. If we have rights and we have responsibilities, from your DG, do you see a perspective where you've got to partner with the education system as well to inform children from an early age that they actually do have rights?
We'll do in practice. One of the I know that is not the solution of the whole problem, but in our financial programs, in particular on the children's rights, one very important thing is to insist in educational terms, to have children that they know what that means, certain social or unsocial acts. To learn children that how to act in justice, or like there is in all the member states, campaigns against drugs in the school. That is very important, and we are stimulating in our programs. But we can't do. You, the NGOs, you, the practitioners, you can do, and we can help.
Okay, but let me ask you about the social benefit, the return on investment. Are we at a stage yet where we can really measure the return on investment by learning from the mistakes of the past in terms of children being institutionalized and really becomes a university for criminal behavior? Have we gone beyond that stage in Europe yet?
I think in general that's an important theme, and we from the side of the European Parliament are ready to support our activities. And again, that's a common responsibility of European societies to create a higher level of better functioning system in the member countries. And frankly saying, I don't see this situation as a financial question or challenge for or some big challenge for member countries of the European Union. That's our common responsibility to create a higher level of well-functioning democracy, and that's practically and that's an aim for everybody, because that's a social question also of the social climate, of the level of the social climate in the European Union generally and in the member countries especially.
Okay, Anna, have you another question?
Yes. I would just relating to what we were talking about before. I was thinking, how would you bring the subject of justice into the curriculum? Usually, I would think this sort of discussion wouldn't be had because children are often protected from any sort of crime or criminals or such. So how would you introduce justice into the school curriculum?
Okay, Francisco.
But again, I insist, either the European Parliament, the Council or the Commission, we can go to a school in Spain or to the Education Ministry in France to say, tomorrow you have 25 hours to do that at the schools. We can't do that. Our role is not that. Our role is to explain that, because each member state must respect the United Nations Convention on Children's Rights.
What are the sanctions, though? If you don't do it, what are the sanctions?
The sanctions against or behaviors against the Convention of the United Nations are national sanctions. The Convention of the United Nations on Children's Rights is a part of the Spanish, Czech, Slovakian, French system law. So you go before the courts. If your public authorities don't respect this international treaty, by the way, this international treaty is considered to be a general principle for the European Union law. And there is not member state, but it is us, European institutions, in our actions, but we are not respecting this convention. You can go against a concrete action, petitions, etc., Mr. Spassky. You see my point?
Yes, but if there's a petition comes to the Parliament, what sanction is there? Is it just a reprimand? Is it a letter sent to somebody saying, stop doing this? What happens?
It seems currently we have a chance to create some political push for the country to open this discussion or some concrete themes also in the press. So there are here some possibilities for us which are currently, frankly saying, limited. But on the other hand, now when the directive is on the table, that's now maybe a new element to try to think also the methods which will be maybe more effective in the connection of the member states. That's a common responsibility of the European Union and member states.
Okay,
Don't forget,
sorry, go ahead.
Don't forget that now in May, we are finalizing the recommendations for member states in the framework of the European semester, economic governance. There is several member states that receive specific recommendations. Your prison system, your educational system, your legal practitioner systems in protection of minorities, vulnerable persons, gender equality, they are not good. You need to incorporate in your policy guidelines the national government, and you will see in 15 days.
Or what? Because we've seen this with some of the member states who had poor justice record, to say the least, and the Commission didn't really sanction. They said, well, you should really change it, and then they said again, you should still really change it, but there was no financial sanction.
But listen, you talking about the European semester. Of course there is a sanctions. It's not sanctions of the Commission. It's sanctions established by the Council. The Commission, the European Central Bank, the European Parliament, we contribute to the final decision. It's not to us to the decision, but the sanction exists. Do you consider that without the European semester, the finance public situation in all the 28 member states would be the same?
Mariam, whose fault is this that has not been implemented? Where do we need to see the sanctions apply? Where does the European Union need stronger teeth when it comes to implementation?
Look, actually, before answering this, I wanted to finish on the question, if you allow me, about the education and how to incorporate this into, justice, information about justice within the education system. So once indeed to use within the education system all the courses that are around civic education, and indeed this will be well developed. And also, again, the work of the NGOs, and I'm thinking of, for instance, Save the Children, which is a leading NGO in promoting child participation and the voice of the child. And they have developed, for instance, a pilot project in Italy recently, and it was about legal clinics. And so it is involving also students in law, and they are providing legal services to children and families about the rights concerning the situation of a child. And this is actually, the idea would be, how can you make a closer link between these places that are centers for access to law and justice with schools and with child protection systems, that those different infrastructure that might exist are there, so that children in the school, for instance, organize visits from the schools to the center, so that they know where the information can be accessed.
I was a law student, and I'm not having a lot of confidence in the fact that that's going to work out, using law students to provide legal advice. Okay, Astrid, back to you on this as well. Where's the leadership got to come from?
I think there are many important stakeholders, and apart from the sanctions and the EU institutions, we need to look into the professional associations. And I think also that's why we try to identify really promising practices and tools that can be used. And professional associations are kind of gatekeepers. They are in contact with the children. They can use the material and the information. And for example, as FRA, we have developing some videos for children on rights awareness. And we need to be careful. It's not only, as you said, it's not about like being part of a proceeding, but it's about the right to information. It's the right to be heard in all matters that affect children.
But if you're a doctor, for example, you have a minimum fitness to practice. How can a lawyer be fit to practice if they don't know how to deal with a child?
They do need to be trained, yes.
And if they are not trained, should they be allowed to practice with children?
They should ask for support by trained people. Social workers cooperate more with psychologists and social workers.
But is this not the professional body's responsibility to enforce that?
Yes.
So we've got the Justice, DG Justice, we have the Ministries of Justice, and then we have the legal professions. That's a really short step to implementation. Why doesn't this happen?
I do think that there's progress, definitely. And
it's well progressing.
Yes.
I mean, the situation is not so bad. We need to enhance.
Okay, Mariam.
Yes, no, and I think indeed, I mean, this is not, we have not to give a black picture, because there are very promising practices here in Europe, and about the trainings that are interdisciplinary. So put in the same room a lawyer, a judge, a prosecutor, a psychologist, and train them on child-friendly language, on child-friendly approaches, on how to hear a child, and then they start to get to know how it works. And a children lawyer, unfortunately, at this stage in Europe, is still a benevolent. It's not a you can be specialized in children as a children lawyer, but it doesn't mean that you can pay for it. Most of the time, there are business lawyers that, next to that, do also children matters. So this is something indeed that needs, the specialization goes with the practice, but it needs to be really like different material provided to them, and they need to be put with the different sectors together so that they can exchange together.
Paul, did you, in your report, did you look at how to fund these safeguards as well? Did you look at what it took to implement them, or were you just identifying the safeguards?
I think yes. I think that's a good chance for effective development. And frankly saying, again back to my background, I'm also from a post-communist country, from the Eastern European country. I see a very, very strong development concerning this question, and it's a very good influence from the side of the European Union to the application of legal system in these countries. So I think, of course, the situation is not ideal, and we have some problems. We see the real situation, but on the other hand, I think that tendency is very positive.
Okay, Astrid, what else do you want to see next? What's the next step here for us?
I want that member states and use those instrumentarium, those practices that have been identified, these areas of improvement, to imply them when they propose the Victims Directive, and that professional associations implement standards and guidelines and develop training modules to make sure that all children, no matter in which role they are, and in all regions in the country, are treated with the same way, child-friendly way.
Okay. Francisco, is this a problem with adults' empathy with children as well, that the process doesn't go quickly enough? Do you think the European semester would get their act a little faster if they understood this?
Well, please, I think it's important, don't misunderstand it. I say that member states with the low level of protection of vulnerable parts of his population, they are name and shame in the European semester officer. That is not, of course, the solution. We had the nuclear weapon, the sanctions against. No, we don't need that. We are in democratic state. The rule of law is impaired. We need to implement it. That is have a plea, because we are here in the radio in the European Parliament. My plea is we need to implement well the directive of protection of children, in particular in one crucial point: legal aid. A minor, a child, has not money to pay a lawyer, so he needs not only a voluntary justice, but for member states, that is the real investment, to have good lawyers paid by the state to protect children from time to time, even against his parents, is a real social investment. And that is not expensive. That is it's cheaper and cheaper if we succeed with children submit to trials that they are reincorporated to society when they are adults. That is the real point. And I would like, and you agree with me, that in our directive, this threshold of full legal protection for children will stay. That is my real place.
Yes.
Quickly, as we finish out.
I agree with you, and I think your question was what is the next step from our side, from the side of the European Parliament, Commission and the Council to finalize the trilogue as soon as possible to adopt the directive, and I think that will be an effective next step concerning this question.
Okay, let's summarize where we've been to today. it's not a black hole of injustice. There's a lot of progress that's been made. Child-friendly justice is a work in progress, but it's maturing, and it's maturing at a decent pace, it seems. There are variations in practice across the European member states. Some of this because of cultural and political backgrounds, like the Soviet era, justice systems developing into more westernized systems. But also there is a deeper understanding of best practices. Benchmarking is beginning to have a positive effect as well. Judges may continue to be something of a lottery when it comes to the discretion of judges to implement child-friendly practices, but this seems to be changing as well as benchmarking becomes clear. The education of lawyers, the responsibility of lawyers to be child-aware as well is not just a matter of funding, it's a matter of education, and that should be part of the process anyway, it seems. The Petitions Committee of European Parliament is a receptacle for public opinion, for influence directly to the parliamentarians, and the fact-finding missions that are currently taking place as well, the role of the NGOs, political and cultural awareness is really something which will impact on the multidisciplinary approach that we have as well. There is a cost benefit, there's a social return on investment, but the principal thing, we need more legal aid for children across Europe. Let me thank our guests today, Paul Chaki, Christian Democrat MEP, Francisco Murillo, Director of Criminal Justice, DG Justice, Dr. Astrid Postadolowski from the European Union Agency for Fundamental Rights, Mariama Diallo from the Children's Rights Specialist and European Child Representative. Thank you for this. And also for our students today, Ariane, Beatrice and Anna Maya. Thank you all for your contribution.
Thank you.
Thank you very much.
Thank you.